Yes, Mr. Master.
My Lord, before the short adjournment, Lord Burrows challenged me to find a case. Sadly, I haven't found a case, but I have found something that supports the proposition that I was putting forward, and it's in Olcock. And may I invite you to turn to page 570 of the 570 of the bundle. H. This is Lord Oliver's speech, and it's quite a long section, but it's where he says that witnessing the misfortune of another person in an event by which the plaintiff is not personally threatened or in which he is not directly involved as an actor, the analysis becomes more complex. So that's the setting point. Inevitably, the impact of the event and its aftermath, whether immediate or prolonged, is going to be felt in the greater or lesser degree by those with whom the victim is connected, whether it be ties of affection, blood relationship, or simply business. In many cases, those persons may suffer not only injured feelings or inconvenience, but adverse financial consequences. And he goes on to deal with financial consequences. The common law has in general declined to entertain claims for such consequential injuries from third parties, save possibly where loss has arisen from the necessary performance of a legal duty. And as we go down to G, a fortiori, the law will not compensate such a person for the mental anguish and even illness which may flow from having lost a wife, parent, or child, or from being compelled to look after an invalid, although there is a statutory exception. He deals with the statutory exception, goes on beyond this, however, the law in general provides no remedy, however severe the consequences of the distress or grief may be to the health or well-being of the third party, however close the relationship. And he says there's no appeal to logic, no readily discernible logical reason why he who carelessly inflicts an injury upon another should not be held responsible for its inevitable consequences, not only to him who may be conveniently termed the primary victim, but others who suffer as a result. Not precisely on point, my lord, not saying in terms what I would have preferred it to say, but as an analysis, the general thrust is there isn't recovery. My lord, my lady, I said I would come to Olcock, and the three reasons why I'm coming to Olcock is to suggest that the categorisation of claims, the control mechanisms themselves, the language used suggests, although it is possible to argue that it doesn't go that far, but does suggest that they had in mind that they were dealing with the general principle of liability to secondary victims rather than simply restricting themselves to cases where there were accidents. And the starting point is, in my submission, the categorisation of claims. If one goes to page 573 of Olcock, paragraph E, Lord Oliver is dealing with the situation in which there can be a relationship between the plaintiff and the defendant. And at D to E, he says this: the answer has, as it seems to me, to be found in the existence of a combination of circumstances, a combination of circumstances. And then he goes on at F to say the common features of all the reported cases of this type decided in this country prior to the decision of Mr. Justice Hidden in the instant case, and in which the plaintiff succeeded in establishing liability are. He then lists those cases. And it is important, in my respectful submission, that he lists those cases by reference to the successful cases that there had been. One, the relationship between the plaintiff and the primary victim. Two, sudden and unexpected shock. And three, that the plaintiff in each case was either personally present at the scene of the accident or is in the more or less immediate vicinity. And then finally, the element of physical proximity. And he goes on to say, right at the bottom at H, it must, I think, be from these elements that the essential requirement of proximity is to be deduced. So what I'm submitting is that Lord Oliver was not looking for public policy reasons to justify at that stage the control mechanisms. What he was saying was the established successful cases fall into these categories. These are the requirements for successful cases. And therefore, I extrapolate from that that what he was effectively doing was saying where there has been a successful case prior to Alcock, then we must allow liability, we must allow recoverability. These are the features that exist in all of the successful claims. These are the exceptions that will be allowed. And so it wasn't simply looking for the public policy reasons, coming up with some control mechanisms and saying this is what we think is fair, just and reasonable. It was saying this is an exception to a general principle or an island of recovery. These are the situations in which the islands of recovery have been held to exist. This is what is going to be allowable in future.
But it's one island with these four requirements, isn't it?
Yes.
Yep.
So, in Alcock, first, they were looking at it more widely than simply looking at accidents. They were looking at the principle of recoverability in general. Two, they had determined that the principle of recoverability was in fact or had been limited to accidents. And three, that's what they decided, therefore, should be one of the control mechanisms so as to restrict the island of recovery to those cases that bore the characteristics of the previous successful cases.
And by that you say they rejected the invitation to go further than the previous cases?
Yes. And, my lady, not simply Lord Oliver, because if we go back to page 562, we see there Lord Ackner at the bottom of the page, H, and going over the page to all the way through to E, Lord Ackner was looking at the cases that had been decided and coming to the conclusion that they determined what the exceptions would be. You see at D is paragraph 4, as yet there is no authority establishing that there is liability on the part of the injured person, etc., as a result of a self-inflicted death. I take 2 points from that. The categorization point that I've referred to, but also it is an indicator, is it not, of the fact that he's looking more widely at liability for secondary victims, and he's not restricting himself simply to circumstances where there are accidents. And Lord Jauncey at 581 letter D, dealing with previous cases, and at D, he says, until 1983, there had in England been no case in which a plaintiff had been able to recover damages for nervous shock when the event giving rise to the shock had occurred out of sight and out of earshot. I use the word event as including the accident and its immediate aftermath. 2 points to be taken from that. First, that again he's referring back to decided cases, but also second, note the language that he used. May I take up something that Lord Leggatt mentioned? I have no intention of cherry-picking the language that has been used, but I submit, when the language that is being used is consistently that of witnessing death, injury and imperilment within the context of an accident or injury, and when the language used is that of infliction of injury, it starts to become important. May I develop the argument about infliction of injury, because that's another term that is used. And it goes back to the points my lord, my lady started with yesterday. Why is it important that infliction of injury is language that's been used? A doctor may owe a duty to a primary victim because of an assumption of responsibility. That doctor will have within his reasonable contemplation, will he not, the fact that if he inflicts injury upon his patient, others, secondary victims, people, relatives, loved ones, may suffer a psychiatric injury as a consequence if that is witnessed. But a doctor told that he has assumed a responsibility to a patient and is then told, oh, and by the way, you are also now going to be liable to an undefined, fluid class of potential secondary victims for not simply days or weeks, but potentially years after the event. If told that's what you reasonably contemplated, isn't it, doctor, he might, I suggest, raise something of an eyebrow. The distinction is that it is easier to suggest that if a doctor inflicts an injury and it is witnessed, that may give rise to psychiatric damage to a relative. it is much more difficult to suggest that if a doctor doesn't carry out an investigation or doesn't make a diagnosis, that is going to give rise to injury to a secondary victim. I'll develop that argument a little more when I come back to the reasons why I suggest that the control mechanisms in Alcock are correct and that they limit the qualifying event to an accident, incident, or an external event, an event external to the primary victim. So, categorisation of claims I've dealt with, and the language used, I've promised I wouldn't cherry pick, but insofar as we go to just look at it, can I start with Lord Oliver at 570? It's a passage I've read already, but I now read it for a different reason. It's at letter H. In those cases in which, as in the instant appeals, the injury complained of is attributable to the grief and distress of witnessing, and here are the words, the misfortune of another person in an event by which the plaintiff is not personally threatened, it becomes more complex. The misfortune of another person in an event, not the misfortune of another person. At the bottom of the page, inevitably, the impact of the event and its aftermath, whether immediate or prolonged, is going to be felt, etc. If we're talking about, as we have already developed before lunch, simply the injury, death, or imperilment of the secondary victim being the event, we've already seen that it is difficult to see a circumstance in which there's an aftermath. There isn't in imperilment, even in situations of death and injury. It is difficult to see how somebody who has suffered a death or injury by natural causes, there can be an aftermath, because it doesn't relate back to anything other than what has happened, the death. 573 G and H. This is not only the language used, but it's the control mechanisms proposed. And I know that, my lords, my lady, you have this point. The common features of all the reported cases of this type, this is at F, prior to the decision of Mr. Justice Hidden are, and we can ignore 1 and 2, but third, that the plaintiff in each case was either personally present at the scene of the accident or more or less in the vicinity, and fourth, that the injury suffered arose from witnessing the death of or extreme danger. I'm not cherry-picking words here. These are the control mechanisms. Now, it may be said, oh, well, he was restricting himself to accidents when he said that. But if he was thinking that it is sufficient for there to be the witnessing of death, extreme danger to, or injury and discomfort suffered by the primary victim, then there can be no reason for control mechanism 3. It was a point made yesterday, I think, by Lord Richards, that effectively control mechanism 3 is OTOs. If the House of Lords, when looking at the case of secondary victims and liability for psychiatric injury generally, were intending to restrict that observation to accidents, I would suggest they would have said so. If they were meaning that it is wider than simply accidents, and it's unnecessary for there to be an accident, then control mechanism 3 has no function. The only other option or possibility is that the House of Lords didn't think or didn't consider a situation at all and did not consciously address their minds to a situation in which there could be a secondary victim suffering from psychiatric injury as a consequence of witnessing something other than an accident. And I suppose that's a possible analysis, but what makes it less likely is what I've indicated as the language used, but also by the fact, and by language used I mean infliction of threat or injury, but also by the fact that it is evident from the fact that they were looking at rescuers, looking at the situation as it encompasses employer-employee relationships, even looking at the question of the primary victim being the defendant, that they were looking much wider than that.
Had there been any successful cases prior to this that were not accident cases?
No. That's my point. Mr. Weir, I don't think he conceded it, perhaps he relied upon it, but my point is that they were restricting themselves to the cases that had already been decided. That informed the language that they were using. It also informed the control mechanisms which they made clear were of general application and not restricted to specific events. And if they're of general application, that means that there needs to be an accident, incident, or external event.
But why doesn't this, in a sense, cut both ways? Because you're suggesting that one possible interpretation is that they didn't consciously address their minds to a non-accident scenario, and one might say, well, as they were looking at the cases that had so far occurred, that's not at all surprising.
What I'm saying is that that is a possible argument. I didn't say it was going to be a successful argument. It's an argument that can be raised, I suppose, but, my Lord, it really takes a leap, not a leap of faith, but it really takes a particular view to suggest that the House of Lords, looking at secondary victims generally, appreciating, because they say it in terms, that there may not be a coalescence between breach and consequence, because they say that in terms. In those circumstances, they simply didn't address their minds to the fact that there may be non-accident cases. And, my lords, my lady, I appreciate that we're talking about the early 1990s, but this is not the Dark Ages. Clinical negligence actions were about, at that time, mesothelioma cases and asbestosis cases were well to the fore at this time. And if they had simply not considered it, it would be, I submit, a surprising conclusion to reach.
Yeah, I was trying to identify when Lord Oliver says at the start of that paragraph the common features of all the reported cases of this type, precisely where he was referring back to, and I think the answer is at the page 472 at H, and over to the top of 473 at A, which, as I read it, tends to support the proposition you're putting forward, that they were looking at the generality of cases in which liability in favour of the, as it were, third party has been established, or is to be established, you might say.
My Lord, that's correct. I can also add the point that everybody went back and looked at Donoghue and Stevenson, and Donoghue and Stevenson, as Mr. Justice Hidden made clear, is not an accident case. He used those terms precisely. It's not an accident case.
I'm sorry, if I could ask my Lord to assist me. Which?
Yes, so it's so at page 572. What's more difficult to account for is why, when the law in general declines to extend the area of compensation to those whose injury arises only from the circumstances of their relationship to the primary victim, an exception has arisen in those cases in which the event of injury and so on. And then over the page, he says, to put it another way, what is the essential characteristic of such cases that marks them off from those cases of injury to uninvolved persons in which the law denies any remedy? So I think the reported cases of this type is a reference back to that.
But if you look, for example, at page 474, which is the list of authorities that were cited in argument, but I don't think have been referred to in the judgment, at least of the House of Lords. One of those cases being Attia against British Gas, which is the case of the house that's burnt and people suffer psychiatric illness as a consequence of that. Well, none of these criteria are directly applicable in that situation, I don't think. But it doesn't mean that it wouldn't be dealt, it wouldn't be in the minds, or well, what I'm trying to say is there were cases around that clearly would not fit what is here being said.
There are no... Well, if you mean by that, my Lord, what I'm saying, the only successful cases were cases where there had been an accident or an incident. The other cases were either cases where, on analysis, the victim was a primary victim, or was cited because there was, as I indicated before the short adjournment, a root and branch attack on the concept of legal proximity. Mr. Bennett Heitner was rerunning the argument that all that was necessary was reasonable foreseeability. And it was lost. And everybody agrees it was lost. So that shows how wide the argument was. Mr. Heitner, if we need to look at it, we can see him making the argument.
You say Attia is actually a primary victim?
Yes. Sorry, my lord, my lady, I may give up on computers. It is Mr. Yeah. It's at 552H. And prior to that, 550. 550 is Mr. Heitner's 550H, where it is established that legal neighbourhood exists between a driver, passenger, occupier and visitor, the only issue will be reasonable foreseeability of injury. Where such a category has not previously existed, the court must determine whether to create a new one on the principles. And then when we come to the decision of the House of Lords, we see it 558, letter F. It was argued for the plaintiffs in the present case that reasonable foreseeability of the risk of injury to them in the particular form of psychiatric illness was all that was required to bring home liability to the defendant. So that's how wide the argument was. And so the point I make, going back to Lord Burroughs' question or point, is that in the context of this case, they were looking at secondary victims and psychiatric injury generally, and they were not simply saying, well, it's this class of case that we're looking at and this class of case that we're looking at alone. And we see it again, just for completeness, 562, letter A. Mr. Heitner relies upon Lord Bridges' speech in McLaughlin and the judgment of Brennan J. in Australia for the proposition that the test for establishing liability is the unfettered application of the test of reasonable foreseeability. And so I'm sure, my lord, my lady, you see where I go. If that is the argument that's being presented, first of all, the House of Lords have to decide whether that is right or wrong, and then having decided that there needs to be legal proximity, they're dealing with what legal proximity means in the context of secondary victims. And they reached the conclusion, and there's no argument about this as far as I can see, that the legal proximity means the relationship not between the claimant and the primary victim, but the relationship between the claimant and the defendant. How is the relationship between the claimant and defendant to be determined? There is normally a direct relationship because of it's within the reasonable contemplation of the defendant that injury may occur. In the case of secondary victims, however, that's not the case, but there has developed this exception, this island. And it's in that context that we look at the language that's being used, and we ask ourselves the question, given that those were the issues that they were looking at, can it truly be said that they simply just didn't occur to them that secondary victims may suggest that they have a claim even when there hasn't been an accident? And we're not dealing with that, with anything other than accidents, and we are limiting our guidance to accidents. They certainly don't say that, and I would say that looking at it in the proper context, that cannot have been the way in which they were looking at things. And so if this was not simply an oversight on the part of the House of Lords and Oldcott, and if the language that they used is all about accidents and incidents, and if the control mechanisms relate precisely to that, and one of the control mechanisms is OTOs otherwise, I invite the court to come to the conclusion that they were actually looking at the specific matters that had enabled cases to be decided successfully. And the references to going through those cases are to that effect. And therefore, not on the basis of principle, but on the basis of precedent, they were saying, this is what is permissible. I'm sorry, my lady, I think I may have cut you off.
No, I thought better of it, don't I?
Wish I could do that. And in one sense,
in a sense, it's not really surprising. This was an accident case par excellence.
yes,
It's the biggest accident case I think we can see in the law books. So it's not surprising they look at previously successful accident cases and develop principles that assume there's been an accident as workable for the purposes of the case which they have to decide. At the moment, I'm having... It seems to be common ground there are no successful non-accident cases. But I'm having some difficulty in thinking that a non-accident situation is charted water.
well, in one sense, my Lord, I agree. But does it matter? I ask rhetorically. Because if they were saying to themselves or to the outside world, this is restricted to these cases, we are not preventing there from being further cases that are to be brought. We are not restricting this. We are restricting our guidance to accident cases alone because those are the only cases that have come up thus far. I suggest they would have said so. And they didn't. And I also suggest they would not have used the language that I've referred to, infliction of injury, accident. They would have used the language of death, injury and imperilment, and death, injury and imperilment alone.
I thought you were saying that having looked at all the cases, they said these are the features that they have. Cases which have those features can succeed, but we're not going to make any further incremental development.
Yes.
In which case, I thought you were saying that the later clinical negligence cases, Shorter and Ronayne and such like, could have been knocked out on that basis,
yes.
although in fact they were knocked out on a different basis, and,
yes.
and hence Walters must be wrongly decided. You'll
Yes.
come to Walters.
Yes, I'll just mention it now. Walters never considered the issue.
No. But what you're saying is that in Alcock, I think, in Alcock, they said these are what the principles are, not just for accident cases, but for all cases.
Yes. And my Lord, these are the principles for all cases. My Lord Briggs then says, well, perhaps they were just talking about, I paraphrase, perhaps they were just talking about accident cases because that's all that had ever been investigated.
Well, right. That's what the case was about.
And that's what the case was about.
But then I was confused because you said that they did leave some room for future evolution, or is that future evolution an incremental development but still limited to accident cases?
Yes, exactly the latter.
I see.
There are only two circumstances in which they expressly deal with the question of incremental steps, and that is ties of love and affection and aftermath. An aftermath of what? Namely, aftermath of an accident.
I have to say, it seems a bold proposition to me that where you've had a series of cases that have only dealt with accidents, the case itself is plainly an accident-only case, that one can then say, from what is being said, that this case saw itself as ruling out any non-accident cases. Nobody had ever suggested at that point that there could be cases outside the accident scenario. Had it been put to the Lords and they had it in mind, you would have expected them to have actually said so. Now, you've used that argument the other way around, but it seems to me that this cuts both ways.
Except for the fact that the plaintiff was actually saying all you need is reasonable foreseeability. You don't need legal proximity, and therefore they were having to address what is meant by legal proximity.
In the context of accidents, we don't know the way in which Ben Heitner was putting it, but he was probably saying all the examples are accident examples. You don't need all these controls. It's just reasonable foreseeability.
My Lord, as I accepted, yes, it's an argument that can be put forward. I'm not suggesting otherwise, but where are we? There's certainly the converse is not true. They at no stage restrict themselves, so we can agree on that. Secondly, yes, you're absolutely right. They're looking at the previous cases and saying to themselves, the only previous cases that have been successful are accidents, and we've got, if not an accident, then an incident. And we're looking at it in that context. But, I say, they go on to look at it more widely, and it's the fact that they were restricting the exception to the previously decided cases that matters. It's not a question of looking for a public policy argument as to why they do that for the moment. It's whether they did that. And they were simply saying, Lord Oliver was simply saying, we are going to allow secondary victim cases where they have been successful in the past. Where they have been successful in the past is accidents. Therefore, that's the first of the control mechanisms. Second, they've only been successful in circumstances where there is a tie of love and affection. That's the second control mechanism. Third, it has to be witnessed by the secondary victim. That's the control mechanism. These were all requirements for the decisions, the successful cases. Now,
well, they were features of the successful cases, which he then makes requirements for future.
Yes, they were the features that existed in the successful cases, and he was saying, in the context of this being, as I would put it, whether or not there should be an extension to the exception that had been brought up, he was saying, in effect, only in respect of previously decided cases.
We don't see a control restriction number one. There must be an accident stroke external event.
No, you're absolutely right. But
so that can be. I'm just not sure whether, this, as I've indicated, it seems to me this is neutral. You can argue both ways on this.
I suppose whichever way it's resolved, it supports your case, not your full case. But on neither basis can the appellants establish their case on the basis of Alcock. They have to develop from Alcock, whichever reading one comes to of Alcock.
And you're absolutely right. But what I am doing with respect to Lord Burrows is I'm banking that and trying to persuade you to go a little bit further.
There is.
I'm not denying that we could develop the law. That's why there's 7 of us here.
Absolutely.
But you're saying that they can't get away with saying, well, it's already got there, and all you're doing is recognising what the law has already been decided to be.
Absolutely. And the next question...
And therefore the reading, the Court of Appeal's reading of Alcock in this case was wrong.
Yes. Well, the Court of Appeal also mischaracterised Nova because they converted what Lord Dyson had actually said to the effect that if there is a distance in time between the accident and the consequence, that is a reason for suggesting that there shouldn't be liability. They converted that into if there is a difference in time between the breach and the consequence. And that was never what Lord Dyson said in Nova.
There's a formidable list of authorities at page 473 to 474, I don't think we have, do we, a list of the authorities cited in the House of Lords, other than by, I suppose, trawling through Council's submissions.
Yeah, over the page we do.
Yes, we do.
Oh, I'm sorry if I...
Following additional cases cited in argument.
Oh, I'm so sorry. In the...
And that's where Atia comes from.
474 middle.
Yes, forgive me. But I suppose my question is this. Has anyone looked to see whether they were shown any unsuccessful cases? Because, as you say, they just refer to the previous successful ones. And it'd be very interesting to see whether, for example, there was a non-accident unsuccessful case.
My lord, my age counts against me, but I wasn't able to do that.
No. We've got
Well,
arguments.
some of these are very familiar.
I'm
Yes,
not
they
sure
are.
that it occurred to anybody at this stage that's brilliant to the law to suggest that in the absence, just seeing somebody die without there being any accident could possibly give rise to a claim.
And that, my lord, is the neutral point that I bank.
Yeah.
But I go slightly further than that, because what I'm trying to say is, what was Lord Oliver intending to do? He was intending to restrict the exception.
There is, I mean, going slightly against your argument at page 411, B to C, there's a sentence beginning towards the end of the line: the difficulty lies in identifying the features which, as between two persons who may suffer effectively identical psychiatric symptoms as a result of the impression left upon them by an accident.
Which page is that?
So that's forgive me, 573, and it's really at letter C. So he's tying it there to an accident case.
Yes.
And to establish, in the case of one who was present, why they recover, and in the case of the others, they don't. I mean, I think in the end, this is almost a fruitless task, I have to say.
My lord, you have my point, and it's not going to get better by repeating it, but it's not a fruitless point in this sense. If you are with me that the law in relation to secondary victims is an exception to the general rule, the question then for the House of Lords was to what extent should that exception be permitted, which means that they have to consider what are going to be the principles that allow them to accept those claims. And the answer to that is those claims that have been successful thus far. We're going to come
This
to...
was a cast-iron opportunity for them to come up with some broader principle, given the horrific nature of what had happened. And they said, no, we're not going to. This is the law, and that's how it's staying.
Yes, if ever there was a hard case, Hillsborough was a hard case, as we found from White. And the other point that I emphasise, and it's also in answer to my Lord Richardson's question, is they appreciated that the exceptions to the general rule had caused difficulty, because as a result of the exceptions, an arbitrary line had to be drawn somewhere. The arbitrary line is not drawn by reference to the general law, because the general law is quite clear. You owe a duty to that person who you reasonably contemplate at the point of your breach is going to be directly affected. You may not like it, but people can understand where the law is. It's perfectly straightforward. But the exceptions had caused problems. Where is the line going to be drawn? The claimant, the plaintiffs in McLaughlin and Alcock all said, it's easy. Do away with legal proximity. Reasonable foreseeability is the test. And if they had been successful, then again, it would have been a massive extension of the law, but perhaps some of the arbitrary problems wouldn't have existed. The Lords in Alcock said, no, we understand that there has to be legal proximity. Good. So we've got these exceptions. Yes. These exceptions cause trouble. Yes. What are we going to do about it? We're going to limit them. How are we going to limit them? The first way of doing it, the most sensible way of doing it, is to say those cases that have been successful will be the exception. Those cases that have never been successful, never even brought, don't come within the exception. Thus far and no further. That's why, my Lord, and if it's fruitless, I'll move on, but that's why I'm not simply banking the neutral point that Lord Burrows suggested that I could.
Oh, I can understand that.
So, whether I'm right or wrong, and this goes to Lord Richard's point, whether I'm right or wrong makes this point. If I'm right, then actually what the claimants are doing is they're not asking you to overrule Novo, they're asking you to overrule Alcock. If I'm wrong, then it's neutral. And you then have to embark upon the exercise of deciding what it is about their suggested control mechanism and what it is about my suggested control mechanism that impacts upon policy. I've got two arguments. First is that the claimant's suggestion that all that has to be witnessed is the death, injury, or imperilment weakens the concept of a relationship between claimant and defendant almost to breaking point. It's weakened already. We know it's weakened already because we know there's an exception. But the control mechanisms in Alcock are there to provide the relationship between C and D. It's weakened if you allow their submission. Why is it weakened? Lady Rose touched upon this. It's weakened for this reason. Two reasons, really. First of all, the category of claimants is not fixed at any point. An accident fixes the category of claimants. We know who the potential claimants are at that point. If the claimants here are, if the arguments put forward by the appellants are right, then the category of potential claimants is fluid. Why is it fluid? It's fluid because the event that is going to give rise to the secondary victim's claim may take place years after the original breach of duty. And in that event, there may be more, there could be fewer claimants, but there's going to be a fluidity of claimants. It's never fixed. Secondly, there is the potential for multiple claims arising out of the single breach. I think it's Professor Malone of St Mary's who suggested a situation in which there was a failure to diagnose a heart condition, and the primary victim was a concert pianist, and all of his friends and family are sat there watching him in circumstances where he then suffers a cardiac arrest on stage. That shows a situation which is completely out of the control of the defendant, or the knowledge of the defendant, where there may be an increase in claimants. But in addition to that, there can be an increase in claims. How so? Take Novo as an example. The stacking falls upon me. As a result, I suffer some minor bruising. That minor bruising leads to me having deep vein thrombosis. That deep vein thrombosis results in me suffering from a pulmonary embolism. That is witnessed and is, according to the claimants, a qualifying event. I am taken off to hospital. in hospital as a result of the pulmonary embolism. I suffer hypoxia, and I suffer hypoxia and a epileptic fit. A different relative watches the epileptic fit. That's the second potential circumstance. And then a couple of days later, or a day later, or an hour later, when there's a different relative who's come in, I die in horrifying circumstances. So not only do we have, and that is not, with respect to the submissions that have been previously made, that is not something that is a construction that is so bizarre that it is never in real life going to occur. In clinical cases, the circumstances in which there are a number of what in the claimant's submissions would be qualifying events, which can be witnessed by different relatives, are numerous. So, a fluid class of claimants. Nobody knows what the category of claimants are.
Well, we know the category. We may not know who's within them. It's got to be a close tie of love and affection. That's a pretty...
Well, my lord, you're quite right. That was a misuse of language by me. No. I don't mean the category. What I do mean is the fluidity of it. No. At the point of the accident, if you are with me that there has to be an accident, the category of claimants is fixed.
Whereas it's not fixed for any situation, or it's not necessarily fixed for negligence, with the example that's been given of a negligently constructed doorway or something. The doorway may collapse in the middle of the night when there's no one there. It may collapse in the middle of the day when there are 10 people standing under it. You can't know. But I think what you're saying is at the time that it collapses, at least then you know that there are 10 people under it. But what you're saying is that for each of those 10 people, there is not just recovery by them, but by an unknown collection of...
Yes, that's why I use the term fluidity.
Yes.
Your first point was that...
I'm sorry, my lord, I missed...
Your first point was that one of the problems with looking at something other than accidents as relevant events was that that maybe years after the breach...
Years after the accident.
Well, I think you actually said after the breach.
Well, it could be the breach in the event that the claimants are right and there is no accident. It would be years after the breach.
Yes, but, I mean, even on the accident theory, there's nothing which of itself means that the breach is going to be, or not going to be, particularly proximate to the accident.
That's
I
absolutely
appreciate
right.
that it was in Lord Oliver's case, but I mean, let's say that the breach is negligent design of a building. It might collapse with lots of people standing on or under it many years later.
Absolutely right. And that's why our argument is not and has not been that it's the breach that particularly matters.
No. But it may be the breach was just a slip of the tongue. That's what I noted.
Well, it's not a slip of the tongue in this sense that if the claimants are right and there does not have to be any sort of accident at all, then as far as the defendant is concerned, the event that will give rise to liability can be years later. At that point, I agree, it's fixed. At that point. But it can be years later. You're absolutely right. There are circumstances, and it's the building that falls down, which is the prime example. There are circumstances in which there may be a breach, and then there may be an accident years and years later. But the difference, perhaps, is that in that case, what is it at the point of the breach that the defendant has in his or her contemplation? It is this, isn't it? If I am in breach, this building is going to fall down. If this building falls down, it's going to give rise to primary victims. Those primary victims are going to have relatives who may witness it. So the defendant in those circumstances is still linked to the claimant, and there is a relationship there. But as I pointed out earlier today, in the case of a doctor, particularly a doctor who is assuming a responsibility to a patient, to argue that because of your misdiagnosis or your failure to investigate, there may in the future be an adverse event which may, but there's no guarantee, be shocking and horrifying, and may, but there's no guarantee, be witnessed by a fluid group of people. If you were to say to that doctor, that's the liability you are taking on by investigating or diagnosing the primary victim's case, arguably he would say, well, that's not within my reasonable contemplation at all. So that's why I say it weakens the link between the claimant and the defendant. So to recap, it weakens it because there isn't a fixed body of claimants. It weakens it because there are many different events that can occur arising from the same breach. It weakens it for the reasons that we've just been discussing. But there's another reason, and this, in the context of clinical negligence, is actually quite important. There has been a breach. My doctor has failed to tell me that I have coronary symptoms. I go back to my doctor a year or so later, and my doctor says, I am most terribly sorry, but we failed to diagnose your coronary symptoms. And as a result of that, you are at risk of a cardiac arrest, and it can occur at any time and in any place. I think to myself, well, I'm not going to tell my family that because I don't want to upset them. As a result of which, when I do have the coronary attack and they witness it, there's a potential claim because they've witnessed a sudden, unexpected event. If, on the other hand, I say to myself, I'm going to tell my family about that because they need to know, they can't claim when it actually happens because it's not a sudden and unexpected event. That is an example of when my Lord Legate said yesterday there has to be fairness between claimants and defendants. Absolutely right. There also has to be fairness as between categories of claimants. And that is an example of when there isn't fairness between a category of claimant. And it's also an example of, and it's just one example, of intervening events after the breach, intervening circumstances after the breach that the defendant has no control over, doesn't know anything about, cannot know anything about, cannot contemplate, that determine his liability or otherwise. And
that's a feature of this type of claim, whoever's right in the present case, isn't it? I mean, just take what one ordinarily would call contributory negligence. Suppose that the person who dies for reasons caused in part by a misdiagnosis is also the author of his own misfortune because of his way of life or his eating habits. The secondary victim, well, the defendant isn't allowed, is he, to pray and aid the contributory negligence of the primary victim as reducing his liability to the secondary victim unless it breaks the chain of causation.
well, it's interesting.
And that seems to be a problem that arises however you resolve the issue before us. In other words, this is an area where there are oddities with which the conventional principles struggle to cope.
Well, to deal with the particular oddity that you put forward, one of the debates in Alcock was whether, if the primary victim was responsible for the shocking event,
yes,
can he be a defendant? And that's a public policy reason to say no. Exactly.
But can he be but can his contributory negligence go to reduce the liability of the defendant? One assumes also no.
But in my example, if I'm right, that's not going to arise.
Yes, but it arises in the driving situation.
Yeah.
In the accident situation, clearly, the person who that there may be contributory negligence involved in the person's driving.
Well, that would reduce the damages payable to the secondary victim, wouldn't it?
Well, that's one of the questions.
Well, that's a question.
Luckily, we don't need to decide with the Law Commission.
I think the only point is this is not an issue that is created or exacerbated by extending this to medical negligence, because you've got that very thorny question in any event.
Well, may I make it clear? I completely agree with that. It's not an issue which points one way or other.
No.
It simply shows that there are ways in which this type of, you say, exceptional claim causes problems which don't seem to be sensitive to your proposed solution. And I was just really responding to your last submission that you say, oh, well, all these things are much more difficult if you get rid of accidents. I'm just not sure they all are.
And it does come into the question of the doctor's duty towards the family. If the doctor knows that his patient, because of the doctor's negligence, is now liable to suffer a cardiac arrest, and he's in some kind of relationship of assumed responsibility to the family members who he contemplates may suffer psychiatric injury if they're not told that there is a risk, does he then properly leave it entirely to the primary victim to decide whether to warn them or not? Or is it his duty to warn them, despite the primary victim not wanting them to know?
My lady, yesterday you mentioned a similar sort of point, namely, well, is a doctor in circumstances where the doctor is aware of the fact that this has occurred, say, no, we're not going to have any relations come into the room because something adverse may happen to them. And what's going to happen there? We're going to have a situation where the doctor says, well, I was looking after these people because I wanted to prevent them from having psychiatric injury. They bring a human rights claim on the basis that they weren't allowed to see their loved one at the point of death. And there's the argument, well, did you, doctor, did you really keep them out because you thought to yourself, this is in their best interest, or were you actually thinking in terms of the duty that apparently you owe them? All of that, all of those questions are directly consequent upon what the claimant suggests, but I haven't answered Lord Briggs's point. And, my lord, I've got two observations. The first is, you are absolutely right that there are anomalies, that whatever I say are going to remain anomalies. It can be argued, and the Law Commission did argue, that having a particular class of people with love and affection, for example, can give rise to anomalies. And nothing I say is going to change any of that. So there will be anomalies. There are difficulties, and we've seen difficulties, and I'll come to incrementalism later, but difficulties when one pushes the boundaries of the aftermath. So there are going to be these anomalies. Nothing I say is going to change the fact that there are anomalies. But I ask rhetorically, are we going to go down the route of extending the exception, which itself is going to give rise to more anomalies or different anomalies, all of which are going to have to be tried out? Because really, the claimant's case is, I have suffered a psychiatric injury. It's reasonably foreseeable. It's as a result of your breach of duty, and it's caused me to suffer the psychiatric injury. Why on earth should I not claim? That's really what the claimants are saying. To which the answer comes back, well, if you allow this claim, then they will come back next week, next year, next decade, saying, well, they decided that. Let's have a bit of incrementalisation, which means that the next hard case is decided in favour of the claimant.
That's the what next argument that didn't impress Lord Russell.
Yes, and it's also the Lord Hoffman point that we don't know what the consequence. Lord Hoffman, if you remember, didn't adopt Lord Staines's observation about floodgates. He said, I don't know. I don't know what will happen. It's possible. But actually, he was going on to make the point that there will be consequences. We don't necessarily know what the consequences are. And what I'm saying is that we are in a situation here where we have arbitrary controls, they cause difficulty, and the claimants effectively are saying, let's move the line. And let's move the line because it assists our claimant. Perfectly legitimate point to take. And let's move the line to assist our claimant. To which the answer comes back, what might that do? Might it create more anomalies? Might it create a situation where now the line is next to a different category of cases where somebody is going to say, well, why am I just on the wrong side of an arbitrary line? Incrementalism means that I should be able to recover. And so it goes on.
I think the point they would make is that we've now had 20 years of an acceptance since Walters that there is recovery in medical negligence cases, and it doesn't look as if it's been causing massive difficulty, I think was the submission they put.
Yes, to which I ask again rhetorically, well, how do we know? We all know that when there are difficult decisions of the Court of Appeal, that will mean that parties have to take pragmatic decisions. And you have no way of knowing how many cases have settled, how many cases have been brought, and so on and so forth. As for the 20-year point, as I will show, following Waters, there hasn't been. Following Waters, there was then Novo, and following Novo, there hasn't been a general acceptance that Waters is right. In Shorter, for example, a specific submission was made on behalf of the defence. This is Novo on all fours. The judge came to the conclusion that she didn't have to decide that, and one can understand why she doesn't want to decide which of two Court of Appeal decisions are right. She can decide it on a different basis, so she did. Moreover, when one's looking at what Waters is about, and my Lord Burrows has made this point to some extent against me, and I'll make it back now. If we analyse Waters, the point wasn't taken, it wasn't argued, Taylor and Somerset wasn't even cited. Mr. Justice Ald's conclusions weren't even cited. And Lord Justice Ward said in terms, we don't have to give detailed consideration to the control mechanisms. So it's not so much that Waters is wrong, it's that the point wasn't argued. The point in Waters, and what was argued, was is a series of events that take place over a longish period of time sufficient to be regarded as a shocking event? And that's what the case is all about. So insofar as I say Waters is wrong, what I'm actually saying is the point wasn't taken, wasn't considered, wasn't dealt with, and therefore one cannot use it as the basis for saying, look, this has been the law interpreted, the law is as in Alcock, interpreted in Waters, and everybody has accepted it ever since. That's not the case.
Can you explain Waters as saying that it was a case in which the mother was witnessing not only the child's suffering but the defendant's negligent conduct? Or is that not on the facts an available explanation?
I wouldn't want to rely upon that, my Lord, because I actually think that I know that I've been saying to Lord Burrows as in Alcock, oh, they must have had this in mind, they must have had that in mind. But in Waters, it's pretty clear that the point wasn't argued or raised or considered, and therefore it would be wrong of me to suggest that there was an implicit acceptance of what I'm now saying.
But you say...
No, I wasn't, sorry. I wasn't putting that high. I was just wondering whether it could be explained on its facts as a justifiable result on that basis, or whether it doesn't work as an explanation of the facts.
I would say, if the point had been taken, it should have been fatal to the claim.
But, and I think we'd probably say, negligence by way of misdiagnosis and failure to spot that someone is actually seriously ill, one can imagine is quite a common form of breach of duty. But apart from Walters, it's not yet given rise to a successful claim for psychiatric injury by a secondary victim. Is that
not one that's been tried out,
no.
But the reason goes back to the point I made previously, namely that the lines of battle have been whether it has been a shocking or horrifying event, objectively speaking. And as I said earlier, of course it's a legitimate inquiry for the court to make, but it's not a particularly helpful inquiry from the perspective of the litigants. A claimant in such circumstances who is having to look for reasons why their event was more horrifying than somebody else's. Pretty unpleasant. And, of course, as I said previously, it's very difficult, isn't it, to have an objective view of what is horrifying. The great value of saying there has to be an accident or an incident where injury is actually inflicted at the time and one perceives that is it's quite easy to say that's going to be horrifying to a loved one. To actually watch my child or to believe that my child is in peril, but to watch my child being crushed in an accident, it's not difficult to say that that's objectively horrifying. It becomes much more difficult to say that something is objectively horrifying when it's as a result of something that occurs from natural causes. And so in the Liverpool case, we have the courts looking at whether or not somebody is in hospital, whether going to hospital means that they shouldn't regard something as horrifying. Very difficult.
That may explain why the courts have taken what appears to be quite a high threshold to cross. A claimant looks as if, when it comes to satisfying the horrifying circumstances in the medical negligence cases that have been litigated, it does seem a high threshold. But the difficulty with taking that submission to its logical conclusion, I think, is that you end up with a situation where you're going to rule people out, even though it's indisputably horrific.
No, indisputably horrific to the secondary victim.
Yes.
Yes, but it has to be objective. It has to
indisputably, objectively horrific to the secondary victim.
The secondary victim will have... let me start again. My Lord Burrows dealt with this earlier today, and you made the point, well, if you have a claimant who has a recognised psychiatric injury, and that recognised psychiatric injury has resulted from, says the doctor, the event that was witnessed, that must necessarily be horrifying. And you're absolutely right, because horrifying to that person, subject to medical science, which might actually go that same way. That's the way the law looks at it. But of course, that's not the test. The test is not whether, in fact, that secondary victim found it horrifying. It's whether the secondary victim suffered injury in circumstances where it was objectively horrifying. And what does objectively horrifying mean? Well, my lord, you may be right that in some cases and in some courts there may be a particularly high standard. But it may be that in another court somebody is going to say, well, the judge has a particular view about what is or isn't horrifying. Doesn't lead to settlement of cases, doesn't lead to certainty, the ability to say, this is going to be a case that is going to be recoverable, or it is not.
And your main submission here is that accidents, it's a much clearer standard to apply.
I'm not suggesting that the problem goes away, but it is much easier for a court to say, and everybody to say, well, if you've watched your child crushed in an accident and you've seen the oil and you've seen that's horrifying.
Can I just come back to my Lord Legate's point, just before we leave it, because I think he was asking you, is there something about the facts of Walters that mean it went over and beyond a case of observing a horrific death? As I understood it, what would lie behind that is that you might say there were events or incidents leading up to that that were being observed that the mother was present at. And as I understood the question, it was, is there something that one should be, from your submission point of view, placing weight on?
And I'm not going to place weight on it. And I'm not going to place weight on it because, in reality, what was happening was a deterioration in the child's condition, not consequent upon what a defendant was inflicting upon the child, but because of the progression of the disease. And Lord Justice Ward came to the conclusion, in the particular circumstances of that case, and in those circumstances, this series of deteriorations was within a sufficiently narrow compass to allow recovery. And he might be right. He might be wrong. But that's what the decision was, and that's not what we're considering here today. What I'm saying is, if the defendant had taken the point, well, that may be right, it may be wrong, but there isn't a qualifying event because there wasn't an infliction of injury upon the child, the case the argument would have been lost.
In other words, it may have been correctly decided on the submissions that were made to the court.
Yes. If you come to the conclusion that actually I am right and that the control mechanism should be an accident, injury, etc., then in the event the case turns out to be wrongly decided, but not because I am criticising the reasoning of the court. It's a point that wasn't taken. On the other hand, if you choose to overrule novo, that, I say, is a criticism of the reasoning of Lord Dyson, because Lord Dyson was expressly confirming Mr. Justice Ould's definition, and Mr. Justice Ould's definition is bluntly a more elegant way of putting accident, incident, by saying it's a traumatic event external to the primary victim.
Yes.
So I'm looking at, we've morphed into the policy reasons that underpin.
You've got one so far, but it's rather a long one.
I'm sorry?
You've given one so far, and it was...
Have I only given one?
Well, in a sense, it was all directed to the weakening of the proximity between the doctor and the secondary victim.
Yes, so the two arguments are, one, weakening of the proximity, now two, policy reasons. And they cross over to an extent. The policy reasons are these. If Mr. Weir is right in what he's suggesting, you have a situation in which there is going to be flexibility, common sense, a close analysis of the facts of the case. There is no bright line that one can actually say, well, that's the wrong side of the line, that's the right side of the line. And so there's no certainty. And if there's no certainty, there have to be either trials or there have to be settlements. And here's my Lady Rose said there was an elephant in the room, namely whether the NHS should be regarded, whether the finances of the NHS should be taken into account. There's another elephant in the room. Why does Mr. Weir struggle to effectively impose another artificial control mechanism so as to limit the impact of what he's submitting? Answer, because there'll be a massive extension of claims. So he says there will be a massive extension of claims unless I do that. And we might like or not like his additional control mechanism, but he says it's necessary to limit claims. Mr. Tyack, on the other hand, says that's an artificial control mechanism, never heard of before, doesn't appear in Alcock, you can't have it. And he may or may not be right. But if he is right, doesn't that mean that there will be a massive extension of claims? That's from the perspective of the claimants, irrespective of my submissions. So the elephant in the room in terms of the distinction to be drawn between the two cases is you either have to have, as Mr. Weir would say, a new control mechanism, or alternatively you have to have, if you go down Mr. Tyack's route, an extension of claims. And the question then is, well, just because there's a massive extension of claims, that's not a reason for suggesting that there shouldn't be. But that comes back to the point, this is an exception, point one. Point two, you don't know what the consequences will be. I promised myself I would never use the word floodgates in this argument.
Use the word
floodgates in this argument. So I'll try very hard to use something else, which means the same thing. To use Lord Hoffman's point, you don't know what the consequences will be. And as Lord Burrows will know, the Law Commission appreciated that it was very difficult to work out what the consequences will be. So a proliferation or a potential proliferation of claims which gives rise to particular burdens in the case of doctors, because there are few areas where I assume a responsibility to one person and then as a consequence have secondary victims' claims imposed upon me. Very few circumstances. Mr. Weir came up with poisoner. I came up with mesothelioma. That's a potential. I am an employer. I negligently fail to protect you from asbestos or fibres. 20 years down the line, you suffer a terrible event as a result of respiratory disease, and it is witnessed by somebody. So that's a potential area. But it's difficult to find more areas than those two.
Architects.
Architects only in the circumstance that we've previously been to, that they're liable.
Yes. Yes, I wasn't thinking of other aspects, but where the building falls down.
Yeah. And
actually, there's a huge potential class of unknown primary victims.
Well, there is.
But how many people are going to be standing in or on or under the building when it collapses?
But we've dealt with that, my lord, by my argument that if you actually ask yourself the question, who's within the reasonable contemplation of the defendant who's building a building at the point of breach, then he will say, well, if I do it negligently, those people who will be affected by it falling down.
Yeah.
In the clinical negligence.
Well, and their loved ones if they have to.
Yes, yeah. And that's why there's liability. But in the clinical negligence case, there is an assumption.
That will crystallise at the moment that the building falls down. Whereas your argument was that this never crystallises.
Exactly. And not only never crystallises, but arguably makes it it's a very difficult proposition to say to a doctor who's assumed a responsibility to a patient, that he's also, in fact, taken on responsibilities to an unknown class, which will continue for an unknown period of time, with unknown consequences. So,
but what do you say to the argument that was put that it's actually very difficult to show that a doctor was liable for negligence in misdiagnosis or poor conduct because of the stringency of the Bolam test, and that itself is a control mechanism?
well, my lady, there is a test that relates to breach of duty. I mean, we're not talking about the existence of a duty of care. We're talking about breach of duty. And insofar as it's a stringent test, it's only a test that says, well, you have to act in accordance with a reputable, responsible body of practitioners. And I ask rhetorically, what's wrong with that? It's you, just as a driver in a car has to act in accordance with the standards of a reasonable body of drivers. The only difference with the clinical negligence cases really is that there is an element of being judged by your peers, because I don't, in a road traffic case, call a variety of people to say, yes, well, I drive at 85 miles an hour along that road. But the only reason that I don't is because that's within the judicial knowledge. So I don't need to call those witnesses. In the course of clinical negligence, you need to have people who are able to say, this is the standard. And it's up to you, judge, whether they fell below it, but this is the standard. So I don't accept that there's a particularly stringent test for clinical negligence. I thought, my lady, you were going to also make the point that has been made against me, which is, well, if Masker is right, there's not going to be a clinical negligence case because they're all misdiagnosis in such circumstances. And therefore, actually, you've got an immunity from any sort of claim. Well, that fails on the language that was used in Alcock, because if I, as a doctor, inflict the injury, then there will be liability. And one can, it's not difficult to consider the number of cases that there will be in which doctors will in fact be inflicting an injury upon a primary victim witnessed by a claimant. In obstetrics, that occurs frequently. One can also imagine a situation in which there is a negligent intubation of a baby. And in the course of the negligent intubation, damage occurs. Well, witnessed by a mother. Well, there's an infliction of injury. So there's no category of immunity here. What there needs to be, however, is this accident, incident, event that is external to the primary victim. Because that's what Alcock was aiming to achieve.
Sorry, can I... this concept of inflicting an injury, are we within the accident
Yes.
arena here?
Yeah.
It's a subcategory, is it?
No, it's not a subcategory.
Sorry.
What actually happens in an accident? The defendant has inflicted an injury or imperilment or death upon the claimant, upon the primary victim. It's not a misdiagnosis case. He's inflicted it.
Right. Okay. So you're saying certain types of medical negligence are accident cases?
Yes.
Right. And they are ones in which injury is inflicted?
Yes. And that's not an artificial concept because of the language.
But in your case, that will still only lead to liability to a secondary victim if they witness the infliction.
Yes.
Not just the ghastly death that may follow the injury.
Yes. There has to be an event that is witnessed that encompasses...
And it's not enough just to witness the infliction. I think there must be something about the infliction which has its own objective awfulness.
Well, there still has to be. It still has to. Yes, it still has to be a horrifying event.
Yes.
Because we're not actually here to deal with that. But as I previously said, and I say it again, if I inflict an injury upon the primary victim, it is much easier to say, if that is witnessed, that that is a horrifying event.
So there's an operation, and the doctor, let's just assume, amputates the wrong leg.
Yep.
His spouse is not in the operating room. What then happens?
So the spouse,
on your submission.
so the spouse comes in as the primary victim wakes up. He's appreciated that the wrong leg has been amputated. He is appalled by what's happened. The secondary victim sees it and says, "What is going on here?" That is the aftermath of the event, which was an accident.
Was it the immediate aftermath?
Ooh.
I think you would have to say there would be no liability in those.
Well, it's the aftermath. One has to debate whether how close it can be linked to the accident. I mean,
That problem exists for everybody anyway.
yes, and I'm not suggesting that those sorts of cases won't occur where you're going to have to determine, or the trial judge is going to have to determine these issues. That's where we are now. It goes back to another point I was going to make, a more overarching point, which is because the claimants are accepting that the other control mechanisms, good, bad or indifferent, must remain, they're not actually asking you to fix the secondary victim problem. They're asking you essentially to change the problem. If they had come along, as Mr. Heitner did, and I think it was Sir Michael Ogden in McLaughlin, if they had come along and said, actually, we've reached a stage, per the Law Commission, where these arbitrary distinctions are so unpalatable that you have to sweep them away, that would be one thing. But they're accepting that these arbitrary distinctions will remain. And they're essentially, therefore, not proposing a fix. They're proposing a change. But that's all it is.
I mean, this idea of inflicting an injury strikes me as not straightforward to apply in the medical context. Let's assume that somebody injects a fluid, but it's not sufficient fluid. It's negligently an insufficient fluid. Now,
well, that's not the infliction of an injury, because it's had no impact upon the primary victim.
No, but
it's just not been sufficient.
Sorry, what I meant was it's negligently insufficient so that the patient then, instead of being made better, is actually not...
But that's a progression of the original disease. The actual event of injecting insufficient drug hasn't inflicted any injury.
Right.
I have a sort of uncomfortable feeling that infliction is a rather clever word for commission rather than omission.
And I wish it were mine. But sadly, it's Mr. Justice Hidden.
Well, I know. I quite accept you've got a splendid stable from which to extract it. And infliction, I think, was picked up again by the House of Lords in Alcock.
Yes.
But not, I suspect, for the purpose of saying, well, it's in a doctor context.
No, I mustn't push it too far.
Commission rather than omission is what matters, because they weren't thinking about doctors at all.
I mustn't push it too far. But it is indicative, is it not, of there being an accident, because it is the infliction of injury that is witnessed.
Those cases will be rare,
Very rare.
I would hope, but because operations and treatment generally don't take place in the presence of anybody else.
Not in obstetric cases.
No, I'm putting on one side obstetrics. But it's likely to be largely limited to obstetrics, whereas if misdiagnosis leading to death is, then that would be more cases. We don't know how many more.
Well, it would be limited to cases where, for example, and there have been a number of cases where there has been a failure to give the appropriate drug. Not too little, but there's too much. So I give my learned friend 100 times what I ought to give him. At the time when, of course, we're in A&E and the mother and father are there, etc., he then suffers a terrible and horrifying response to that. There's a recovery. So I'm not trying to suggest that there are hundreds and hundreds and hundreds of these cases all waiting, but I am saying that it is a mischaracterization to suggest, as I think may have been Mr. Pitcher's suggested, it is almost never going to be the case that there will be such an event in clinical negligence. That's not so. Or Mr. Weir's point in writing, this is an effective immunity for the NHS. It is not so. It doesn't go that far.
I mean, I have to say for myself, this infliction by giving too much drug as opposed to not giving enough doesn't seem like a very stable or sensible dividing line. You know, suppose insufficiency of a drug is given, which causes terrible fitting to occur in the patient on the operating table, or insufficient anaesthetics given, so that they wake up mid-operation and they're screaming, and that's witnessed in some way. I mean, speaking for myself, I'd struggle to say that the divide you would seem to be offering us between infliction through giving too much drug and something else through not giving enough drugs would provide the answer in that case. I mean, I do wonder whether one wouldn't be inclined to say, even if one goes down your route, that the doctors have brought about the horrific situation, whether it be through what one might, on one view, characterise as an omission, or on another as a commission, not being too fussed about whether it's an omission or a commission, but the involvement of the doctors through breaching their duty of care then and there as part of the incident, which is itself horrific, would be enough.
So, my Lord, as I think I've said once already, I don't want to push the use of language too far. I used the language of Mr. Justice Hidden because it is suggestive of an external event that is applied to the primary victim. I can see that if the language of infliction is used as a substitute for commission, it can provide, as Lord Briggs was suggesting, it can provide difficulties, because I don't want to, and with respect I agree, we don't want to get into the arcane world of commission on the one hand and omission on the other.
But there are going to be some hard cases, and the point is that I think many people would think there is a clear difference between, let's say, the doctor who misreads the amount to inject and injects 100 times the dose, as a result of which the person suffers agony and dies, and the case where the doctor fails to spot something wrong with the patient from which they die of through natural causes. Yes. And we do think differently about those in causative terms. And the fact that there may be a line to be drawn somewhere in between doesn't mean that there's no distinction there.
Precisely. And one can object to the particular language being used. Well, maybe infliction isn't apposite for every situation. But we are still looking for the situation in which the defendant can be said to have the secondary victim in mind and ought to be liable to the secondary victim. And there is a distinction to be drawn between somebody who is simply not carried out the correct investigation for a primary victim and somebody who has actually caused the primary victim injury by what he or she has been doing.
It's actually a very important distinction in medicine, because at the end of life, you're allowed to stop the fluids and the feeding people but you're not allowed to inject them with a massive dose of something. And that is fundamental to medical practice,
Yes.
the distinction between killing somebody and letting them die.
Yes, the oath that doesn't exist, thou shalt do no harm.
But you're using this distinction to tell us what's an accident or not, as I understand
Yes.
it. Yeah.
Yeah. Because the word accident, and I don't distance myself from this. The word accident, as used in McLaughlin, as used in Alcock, is of itself not a particularly precise term, and the word incident has been used, which is why Mr. Justice Auld actually came to the conclusion that what it means is a traumatic event external to the primary victim. And that is, as I said a little while ago, a more elegant way perhaps of putting what is hitherto described as accident or incident. But that's what we're looking for. And if we can find that, then it can be a qualifying event. If we can't find that, then it isn't. Why do we bother drawing the distinction? For the reason of legal proximity, but also for the policy reasons that we've been discussing. There isn't certainty. There's increased claims, certainly the potential of increased claims. There's increased events. There's the interpolation of what may happen and what a primary victim may choose to do, which a doctor is never going to be aware of. There's the happen chance of it. There's the fact that it looks unfair to another category of potential victim. It's the fact that the aftermath principle is difficult to actually fit in with what is being suggested by the claimants. All those are good policy reasons for saying, don't move the line, and in addition to that, you don't know what the consequences will be.
You run out of steam.
That was unkind, my lord.
I meant it in a perfectly friendly way.
Well, I'm going to say no, and I can keep going. But
No, but seriously.
seriously, I think that what I would like to do, if you would permit me, is to just gather where I am now and finish tomorrow morning.
Well, we don't have to sit late. I know we're booked to go until 4:30, but we could perfectly well rise at 5 to 4 or 4 o'clock. It's been quite a punishing schedule up to now. And the bench, the bar, has received probably an almost unprecedented amount of badinage from the bench.
Can I just ask before you sit down?
You wanted to collect.
I don't know whether you're going to address this tomorrow, but the Walters case itself, I was just actually looking at the cases judicially considered, and there is a case there. It's only, admittedly, it looks to be a county court case called Tredget and Bexley Health Authority, which Lord Justice Ward relies on. This is at page 657 of the bundle. Which looks like an early example of medical negligence triggering psychiatric illness to a mother, in which he appears to be applying Alcock. And I'd be interested to know, when you come to that decision, if you are coming to it tomorrow, what you might say about that decision.
Thank you for the warning, my lord. So what I would propose to do tomorrow is to look at Waters and how and whether it assists us to demonstrate the point that the argument now wasn't taken, to demonstrate, if I can, that first instance decisions have followed to some extent the Waters line or followed the Novo line. and to bring in the reasoning of the Master of the Rolls in Nova as supportive of the submissions that I'm making.
Could I just add that Lord Roger in JD in East Berkshire, paragraph 107, makes reference to the same case that Lord Burrows has referred to. He's obviously, he collects together that case and Walters as exemplifying a particular approach.
Yes.
I think it follows that we can start at the usual time of 10:30 tomorrow.
Yes.
That's not good.
I have a timetable taking me to midday, and I'm not going to use it.
Taking you to?
Taking me to lunchtime tomorrow, and I'm not going to use it.
Good. Well, unless anybody else has any questions, we'll rise now and resume tomorrow at 10:30.